Good afternoon, everybody. Welcome to the US Inventor webinar called In the Trenches with the Inventors. Today, we have an amazing panel lineup of inventors who are going to talk about the how and the why their patents were invalidated. You might ask, well, I spent a lot of money and time getting my patent put together with a patent examiner. How can you tell me that it's going to be invalidated? Well, we'll find out more. Well, let's just quickly look at our agenda. We're going to try and keep things up to 45 minutes in length. There's also a Q&A button that you can type your questions into at the bottom of your screen, and we'll try and answer those questions for you at the 2 allotted slots that we've put into our agenda. Firstly, though, let me introduce to you a man that really needs no introduction, the president of US Inventor, Randy Landrenau. He's been battling on the behalf of inventors' rights. Randy, over to you.
When I first learned that big corporations were trying to get laws passed kind of on an ongoing basis to make it harder to stop them from just taking something an inventor had invented and patented, I got very interested. I could not walk away from that issue. And it's been going on actually since about 1850, but it wasn't until recent years that they got really good at pushing it through. And, you know, you look at America, I mean, for about 200 years, America was the place where inventors had real patent rights. And you go back to the very founding of the country. If we had not had the vision of our founders to give the right to common people, the right to own what you have invented and patented, man or woman, that was so revolutionary in the world. And that's what led America to be the worldwide leader in innovation and what changed the world. And of course, what made America so different than the rest of the world. And for a couple hundred years, that was the case. Unfortunately, that has changed. And the purpose of this seminar or this webinar is to give you some real data on what has happened and what we're fighting. And we're fighting to change back to restore the rights of inventors in America. It is so critical for the future of this country. So that's the purpose of this webinar.
We had many people register and answer initial poll where we were asking them if they'd heard of Ptab, and remarkably, a lot of people hadn't. So could you just clarify very quickly, what is Ptab?
So that is the Patent Trial and Appeals Board. We call it Ptab. That was created by the American Invents Act in 2011. It is an easier way to invalidate an existing patent, okay? It was sold or billed as a cheaper, faster, less expensive, but fair alternative to district court. That's how it was sold to Congress. What it actually ended up being is pretty much a killing field for patents. And the inventors who are going to be, you'll hear from shortly, will describe their, what they've experienced with the Ptab. Basically, the Ptab is what corporations use to invalidate your patent if you try to stop them from infringing a patent, because it is so effective and they have about an 84% kill rate when they use it. So this is what we're fighting. And we as inventors, by the way, just so you know, prior to the Ptab, if you had such a fight underway with an infringer, it was done in an Article 3 court. That's a court with a jury and a lifetime appointed judge and a lot of due process. Well, the Ptab doesn't have that. There's no jury. There's not much due process. There's no lifetime appointed judge. You have a panel of attorneys who call themselves judges who are typically attorneys from big corporations, It's very unfair and inventors are being wiped out and it's very expensive. And I know, Natasha, you want me to go fast here, but one of the key things that inventors have to have in general, at least the average inventor, is to be able to fight an infringement case on contingency, right? That's where the attorney shares in the winnings, so you don't have to come up with $500,000 up front to fight, because how many of us have that much money? In fact, Steve Jobs didn't have it when he started. Bill Gates didn't have it when he started. The Google guys didn't have it. Bottom line is, in America, these fights are expensive. And if you can't do it on contingency, you can't even get started. You have no access to justice. And that's what has happened now, because Ptab fights, it is almost impossible to get an attorney to take one of these Ptab fights on contingency, and they cost hundreds of thousands of dollars each time you have to go through one. So you'll find more about it as we go on here, but it's very important that we change the system and we restore the rights of inventors.
Absolutely. So we're going to start talking with our guest speakers, but before we do, we're going to run a small video that was featured last year. Glenn Sanders was actually presenting his case to the Ptab, and a group of inventors from US Inventor went outside to protest. So let's just have a look at that video.
I'm Randy Landrenau, the president of US Inventor. I'm here in front of the Gaylord Resort with a group of inventors and their families, and we're here standing up for inventors and to try to restore the rights of inventors.
We're here at the annual convention of patent attorneys. It's called the American Intellectual Property Law Association.
American inventors with valid patents are having those patents invalidated. In fact, there's even one of those trials going on right now across the street.
A real trial, not a mock trial, at a trade show.
The trial is so important today because the patent hangs in the balance for a company called Zaxcom who invented wireless technology.
Their competitor took it, they didn't want to pay them for it, and they thought they would take advantage of the Patent Trial and Appeal Board.
Our goal is to educate people on the system and how the system is not really working to the inventor's benefit.
I guess the good thing about it is we're able to expose how this works.
In 2011, the American Invents Act created the Patent Trial and Appeal Board as an administrative tribunal, an unconstitutional death squad to patents.
Every time the Ptab gets their hands on a patent, they find a mistake.
We need inventors. America loves inventors. And so, why is this going on?
I applaud you guys for standing up for your rights.
Thank you all for coming out here today, and thanks for supporting Glenn. And I'm really glad I didn't have to stand out here by myself with my sign.
It's my absolute pleasure to welcome Glenn from Zaxcom. He's actually won Emmy Award and essentially a technical Oscar for his wireless technology microphone. So Glenn, thank you for coming. Please tell us about the battle that you've been facing and the difficulties that you've had to endure.
Thank you, Natasha. Hi, everyone. So I'm Glenn Sanders, president of Zaxcom here in New Jersey. And we are involved with the manufacturer of recording equipment for film and television. And as you can see behind me, I've been honored with a few Emmy Awards and Academy Awards, and that's all really great. Specifically, one of these awards is for our invention of digital recording wireless, where this little unit here is a transmitter that incorporates our invention, which is the ability to record and transmit audio at the same time. When we invented this in 2005, it was unheard of and a very unique thing and a very inventive thing. And because of that, the Academy of Television Arts and the Motion Picture Academy basically, without hesitation, gave us awards for doing it. Which figures into secondary considerations that I'll get into. The Emmy Award is actually entitled for digital recording wireless microphone. So there's a direct nexus to the invention, in the patent. So, so you shouldn't have any ambiguity that the awards are directly tied to the invention and the patent. So after we had our patent for about 10 years, one of our competitors decided that they had to have it too, and decided that they were going to infringe the patent. Well, immediately we basically notified them and said, you can't do that. I mean, we have multiple patents on this. We actually have 3. And we had to file suit against them in New York, actually, because they had an office in New York. And unfortunately, because the way the patent laws are, the case had to end up in their jurisdiction, which is New Mexico. So that was quite an expensive thing to fight as well. And unfortunately, we really didn't have much of a chance because that's the way the law is. So the case got moved to New Mexico and was getting underway when our competitor decided that they would file 3 IPRs against us. So these IPRs basically sought to invalidate our patents. They were claiming that the patents were obvious, the patents were, were not unique, that it had been done before.
Glenn, let me stop for 1 second. So to the listeners, an IPR is an inter partes review. It's done at the PTAB, right? So that is a PTAB, those are PTAB actions he's talking about. Go ahead.
Yes, exactly. To me, yes, they are one and the same. So basically, they filed these cases, and what they did, rather than pay us a royalty or license or whatever it was going to be, they decided that it was going to be less expensive for them to just try to invalidate the patent, because the infringement was actually on a little separate recorder box that connected to the transmitter, which was covered by our patent. Their ultimate goal was to make a recording transmitter, which they have subsequently done, but our patent, which is still in effect, we were actually not one of the 84% that lost our patents. We actually came out fairly well in this proceeding. But by fairly well, what the PTAB did is they looked at the evidence brought by our competitor, and that evidence was made up of third-party patents. So they basically went throughout the world and decided, what can we find and what can we use to show that there was prior art? And they couldn't find any. So what they did is they found a patent for a backpack that recorded audio and video. Now, if you can imagine, this is something that is very small. I mean, literally, here it is next to a pen, okay? So this could be hidden on an actor, actress, and you wouldn't see it. What they found was an actual backpack, okay, something that you would wear when you're hiking that could never be used for, this kind of thing. And they also found something that's related to this, which is something that protects the transmission from dropouts, because the idea, very simply, is that you're going to replace dropouts, okay? Because if you have a dropout of the RF, the internal recording could be used to save the audio. So they found a device in a completely unrelated art of television broadcasting and said, if we combine this thing that requires thousands of pounds of equipment, a shopping cart full of car batteries to run, so thousands of pounds of equipment, and we combine that with a backpack, then we've got something identical to this, which is just insanity. So instead of the PTAB doing the job it should have done and rejecting the case because the art brought forward had nothing to do with our invention, they said, oh, yeah, we'll hear this case. And they did. So to me, that just kind of blew my mind that they would actually not follow their own rules of reviewing a case to see if the art presented had anything to do with the patented art. And, it had as much to do with a flashlight and the sun. Both generate light, but I wouldn't want the sun in my pocket. So in any case, so they instituted the case, they heard the evidence, and besides hearing this evidence in unrelated art that could never be combined to do what we do, we had something else going for us. It was the secondary considerations. The fact that our industry, the film and television industry, has said with these awards that this is important, this is unique, this is not obvious, and we are telling you in the world that, this is important, so here are your Emmy Awards. I mean, this is the Nobel Prize of what we do. So the court, so the court basically said, okay, we see these Emmys, but, they don't exactly match up with what this is, because the Emmy was given for, this product, which has other features. So since there are other features, we're going to, for the most part, ignore the Emmy, ignore the Academy Award. And in a nutshell, basically, they said, we are going to let you, quote unquote, keep your patents, but we're going to amend it. And when we amend it, you have no right to get damages from the company that ripped you off for as many years. So while we don't fall into the 84% of people that lost all their rights, we did lose the ability to get damages. So we're now appealing that in the appellate court in order to get our rights back, because it is insanity to have awards that say this is for recording digital wireless, and to say, oh no, it's not, it's for something else. Effectively what they did
All
is
right, so Glenn, I have to stop you there. I think it's interesting to learn that your insight that you didn't completely lose all your rights, but what do you think you would have liked to know before you went through this process? And if you could just answer that in a very brief sentence.
I think I would have liked to have known, how fair it was or wasn't fair, because in a nutshell, the judges were they just weren't able to look at the technology presented and to make a determination of what was doable and what was not. They took the word of the larger company to say that they could put together all these things that were unrelated and come up with our invention, which clearly, because it's physically and practically impossible to do. But they chose to cut the baby in half and give them something and give us something. So it would have been nice to know, that it was a fair thing, but the judges just weren't capable of comprehending or didn't want to comprehend what we had to say, and basically took the easier way out of just cutting the baby in half.
Hey Glenn, would you?
Thank you, Glenn.
Let me ask you something. Yeah, Glenn, would you say that the Patent Trial and Appeal Board judges had less experience than the patent examiner, yet they didn't talk to the patent examiner at all in your case?
Well, by far. I mean, the patent examiner, looked at everything that we provided. They then went to look for prior art and frankly found things that we had to argue over those things, and we were able to very successfully do that. This is a patent related to sound and RF transmission, and the judges on the court were not experts in these things.
Right.
They were only as good as what they were told, and the other side was telling them fanciful exaggerations of what was possible. And, we were telling them the way it was, and unfortunately they were bamboozled effectively. And like I said, just decided to split it in half.
Gotcha.
All right. I would love to talk for longer. It's an amazing insight. Thank you so much, Glenn. So we're going to introduce our next guest. This time we're going to introduce Tom Pearson. Randy, I know you have a good relationship with Tom. Would you like to introduce Tom and talk about his amazing accomplishments?
I think I'll let Tom do it. Tom, go ahead.
Thank you, everybody. Thank you, Natasha. Well, yeah, my name's Tom Pearson, and I'm the founder of a technology called turbine inlet chilling. Specifically with, we call it generation storage because we store energy off peak and then use that energy to make even more energy during the daytime in a gas turbine. So this is a technology that I've been involved with. Basically, I'm considered pretty much the godfather of this industry. I started in it in 1982. Worked on it for 7 years before doing the world's first turbine inlet chilling job in 1987, and continued to improve it over the next roughly 9 years. And in 1999, I did what I considered the ultimate best way to do turbine inlet chilling, which involved stratified chill water thermal energy storage tanks and chillers arranged in series and variable flow, a variety of concepts. But and I did a particular project for a power plant in Texas and realized I need to get a patent on this. So I did. I got filed for that first patent within the 1 year of that project. and followed that with 4 more patents. So fast forward, so that was in 99. And prior to that, like I said, I did the world's first job in 87. And during the 90s, there were a number of competitors that were also doing inlet chilling, but doing it different ways. And our primary competitor, who is based in Florida, always did theirs with ammonia, direct ammonia refrigeration to the coils. And we were doing it completely different, right? Chill water, series chillers, and then later with thermal energy storage. Anyway, so fast forward, as the technology got more adopted, I started a company. I left the company I was with, which was Train. They make the chillers. And in 1999, shortly after I did that first project I talked about, I started a company called Turbine Air Systems. It's known as TAS Energy today, and I'll explain why we changed the name. But it was Turbine Air Systems, and all we did was turbine inlet chilling. And we did that for, well, from 1999 on. Well, there's a lot of work that goes into creating these projects because we're disrupting a industry, a very old industry, the power generation industry that has, done certain things away for 100 years. They're very hard to change. We spent a lot of effort with PUCs and you name it, but we felt that was a good investment of time because we were protected with what we thought was our intellectual property. So this company that in Florida, they started seeing our success, and so they basically switched and basically just started copying exactly what we did. Not only copying what we did, but just following us around. I mean, they would openly brag that all they do is follow TAS around. We would create a project. Utilities have to have a competitive bid, but instead of bidding it with the way they would have normally done it, they just said, well, we'll do exactly what these guys do. We'll just be a little cheaper. And of course, they didn't have any of the invested cost or sales cost or all of that. So, so make long story short, there was a project in Florida, their home state. We're based in Texas. We'd been working on this project for almost 3 years to get it to go. It finally went. It was a Florida Power and Light project. And so they bid it, again, just more or less copying us. And we kept telling these guys, you guys know we not only have 1 patent, we have 4 patents, and with 4 different examiners, and they all cover these same basic major claims. And they didn't seem to worry about it. So they won the project primarily because they kept lobbying their own state people. This is in our state, you need to hire us. So anyway, they wound up doing it. And our only alternative was to sue them, which we did. Well, I always thought it was weird when we sued them. Again, they're based in Florida, we're based in Texas, but when they hired their patent lawyer, he was from Washington, D.C., which didn't make any sense to me. But later on it would. So we got a little bit into the trial process. And then the next thing I know, our attorneys are telling me that they have filed multiple IPRs. And I said, what's an IPR? I'd never heard of it before. For me, it was pretty, I don't know why more inventors don't know about the IPR process, but I did not know about it. And so they stopped the litigation in Florida. We then go to fight the IPRs. And like I said, they filed 4 IPRs. And I thought, well, there's no way in the world. It will be impossible for them to win because it wasn't just 1 claim, it was a bunch of claims with 4 different patents and 4 different examiners. But to make a long story short, they did prevail. The examiners actually rejected every single claim, every one that was contested, and to echo what Glenn had said, it appeared to me that these judges, I couldn't even tell that they'd even read what we wrote. I mean, we spent a fortune with attorneys, and I had to educate the attorneys because they don't understand the technology either. But we spent a huge amount of time on these responses. And then when the examiners would reply back, it was almost like they didn't even acknowledge or read our deal. Matter of fact, it almost appeared to me that their response was written by the opposing counsel.
Hey, Tom.
Again,
let me just ask you.
Sure.
You keep referring to the examiners, but what you're really talking about is the PTAB judges, right?
You're exactly correct.
Right.
Sorry about that.
And for our
Yes.
listeners, so the PTAB judges make these decisions without talking to the patent examiners, who are the experts who granted the patent. I just want to make everybody aware of that. So I'm going to sign off. Go ahead. Keep going.
Well, yeah, they
right.
do that. And on top of that, you as the inventor never even get to talk. Never.
I want to show a small snippet from the movie Invalidated, where you explain exactly how you feel about this process that was put on yourself.
They copied exactly what we were doing, what was in our patent. So we felt very confident that our intellectual property rights would protect us. But we found out that that's not the case. Our very first one, invalidated. Our second one, invalidated. Our third one, invalidated. And our fourth one, all invalidated. Every single claim that was contested. And it would actually, a much better process would be, as soon as a patent is issued, somebody at the patent office flips a coin. Heads, the patent is good. Tails, it's no good. Biggest winners are the lawyers. The losers are almost everybody else. I never would have dreamed that we would even have one of our patents invalidated, much less all four of them. We're not able to utilize any of them. So we've already spent the money, and we leave them on the wall. I guess it's better than having a blank wall.
Well, I think it's a terrible shame that those patents were invalidated, and also that means that people won't get the ability to use that technology either. So thank you for joining us on that, and we will probably take some questions later on. Ray Perkins, I just saw Randy at the same time, so my apologies, is Ray Perkins, and Ray came up with a slow release compound for urea-based fertilizers that reduces pollution by 30%. Now, I'm going to pass you to Ray because he can talk more about that. And what happened to you, Ray, and what was your experience with Ptab?
Yeah, if I can just, I don't know who's watching and who's just listening, but tell you a little bit about the product and then what happened to us. But if you can see, this is a product, a liquid product that's a active ingredient and a solvent. And what this product does is it goes onto urea, and urea is a multi-billion dollar, about a $40 billion industry. Fertilizer industry is about a $60 billion industry worldwide. But it goes on these products, these urea products. We call it colored urea versus white urea. When you put this solvent onto this material, what it does is it prevents volatilization into the ozone or leaching into the waterways. So ultimately, these products, what they do is they prevent things such as red tides, algae blooms, phosphates and hypoxia, fish kills in the Gulf of Mexico and into the Chesapeake Bay. So that's a little bit about our invention. We filed our provisional October 1st, 2012, and our non-provisional May 8th of 2013. So it didn't take long for us to get into this process. Immediately coming out of the gate in 2014, we had $14 million in sales, which for us was a big deal for a bunch of rural guys from North Carolina who just invented something more or less by accident. Immediately upon that, when these products aren't treated, the fertilizer either goes into the waterway or it goes into the atmosphere, which the only people who love that are the fertilizer producers. So we had 14 million in sales in 2014, and we've had a suit filed against us by Koch brothers, who, golly gee, just by chance happens to be a fertilizer producer. We had 21 employees at the time. We're down to about 4 now. But they went out and informed the customers that patent infringement cases could be brought if you made, used, sold, promoted for sale these products. So naturally, the customers ran from us. That suit was ultimately settled, terms which cannot be disclosed. In the process of that suit, we were approached by a company, a big French multinational or Belgian multinational company, multi-billion-dollar company who wanted to buy these technologies. Ultimately, the partnership fell apart. And since then, they have filed 14 patent applications for patent technologies that are very, very similar to ours. In 2018, we decided to re-enter the commercial market to try to sell these products ourselves rather than pursuing a licensing type strategy. We in turn had a declaratory judgment filed against us in Northern District of Iowa from a multi-billion-dollar company out of Japan, Marubeni, one of their small companies that they own. Ultimately, Solvay ended up filing a PGR and IPR and 2 actions in Brazil against us. So now I can tell you a little bit about the PGR. The PGR was found. We lost that. We invalidated, of course, but the manner in which they did it was they took an obscure Chinese patent that was for urea production in a big granulation facility. Had nothing to do with putting this little coating on this. It had to do with a big manufacturing process. So very loosely analogous art. And they combined that with a patent that had 10 to the 32nd. That's how many solvents were in their patent. That's a lot of zeros. None of them were ours. But that became obvious to the Ptab judges. So on top of that, there was a unverified translation that was ignored. Our opportunity to argue that was not granted. Coincidentally, one of the judges, we've heard this mentioned, conflict of interest. One of the judges worked for a company that 2 years earlier had closed a deal with none other than the petitioner Solvay. Again, there was no technology out there prior to ours. Now there's 7 that are basically using what we would call infringing our technologies. On top of that, Solvay's 14 patents that they've filed, they've used inconsistent arguments. They've argued one thing in the PGR and another in their prosecutions. They filed an IPR that was just accepted on Friday, again, using the same prior art references. That many solvents, none of which was ours, with a obscure Chinese patent, and that is obvious. So they've attacked us twice more in Brazil. And it's really because we're a dominant patent. Our technology, the key to this is a product that is called DMSO. And they've used these, they suddenly have found unexpected results when DMSO is used with anything from, carpet fibers to anything to get a patent and go to customers and say, we have a patent, although we're the dominant patent. So they need us out of the way and don't want to pay for it. And that's really our story. So we're one of the ones that are currently under attack. So I should mention that also these technologies that were combined, that many, were examined in a parental application by the same examiner who examined their patents and examined our patents. The examiner was never asked about this, never approached. So that's our story. I hope I kept it to 5 minutes. So any questions, Randy, that you have?
I wanted to make a comment that, so here we have and by the way, Ray mentioned PGR and IPR and a few other things. Those are all Ptab actions, okay? So these are all done at the Ptab, which is this unfair court. There are a couple things here. This is a Belgian company that has invalidated his patent. And in fact, I know of other cases. In one case, a Chinese company. So foreign companies can use the system to invalidate American patents. That's terrible. Secondly, the lack of due process. And in your case, Ray, you were unable to even argue about a mistranslation of an earlier patent that was used against you. In a real court, you could have made that argument, right?
Correct.
And not the Ptab, because there's a lack of due process there. It's all bad. And the other thing is, the more valuable the patent, the more likely you will be Ptabbed, and the more likely you will face multiple Ptabs if they don't kill your patent on the first one. So, I know we have more inventors to go. So let me send it back to you, Natasha.
Thank you, Randy. Well, I think we have a couple of questions. And what question? Oh, this is an interesting one. Can you represent yourself before Ptab? Anyone want to answer that?
I can take that one. If you're an inventor and you hold the patent in your own name, and some do, we'll have an inventor on in the next week or two that has the patent in his own name. You can represent yourself. But if you've assigned your patent to your company, then you have to have either an attorney or a registered patent agent to represent you. But more than that, it's really not possible. This has become an inside game where you have to be one of the top 3 firms that are entrenched in Washington, D.C. and entrenched to the patent office so that you know all the tricks and channels and latest things. It's a very confusing, political, unpredictable process. So in certain cases you can represent yourself, but I don't recommend you do. To get adequate representation, the Ptab means hiring one of these top firms, and it's close to about $1 million in legal bills to really get the representation you need to survive a Ptab.
Okay, thank you, Josh. Another question here. How are the Ptab judges selected for a particular case?
Yeah, we don't know. There's no transparency in this process. We don't know how they're chosen, how they're hired, or how the work is divided up. We do know that from time to time when they want to achieve a certain result, they will use a procedure called panel stacking, where one of the management of the Ptab will come in and reconsider a decision and then overturn the first decision. So they kind of let them do what they like. We're not sure how the initial assignments are made, but if the top dogs don't like the outcome, they will come in and change the outcome of these proceedings. This is actually one of the areas that's being challenged in the courts as a violation of the appointments clause and due process. And so that's one of the areas that's definitely under scrutiny right now, but we don't know.
All right, well, thank you, Josh. I want to roll again another segment from the Invalidated documentary, and this particularly gives you an overview of Ptab, so let's roll that video.
The Patent Trial and Appeal Board. So under the American Invents Act, they created this new division of the Patent Office. It was shocking, the dichotomy between what happens in a real court of law where you're having a dispute about property rights and what happens in the Ptab. You show up in this modernist courtroom, there's this high bench and these attorneys sit behind this big desk. They're kind of peering over the monitor, and it's all technocratic. 1 or 2 of these guys will be live, and then 1 or 2 will be remote, like on Skype.
So what is this Malone? Received record, obscene telephone contacts.
They call him an administrative patent judge, but he's not really a judge, and I don't know what to call these guys. No testimony, no jury. They told the Ptab that the same argument. No one can understand when a balloon is substantially filled with water. And in this case, they agreed with them.
Okay.
And they said, you're free to copy Josh's invention. They've taken this patent that I've earned. I've followed the law. I didn't cheat, lie, steal. The examiner didn't do anything wrong. The district court doesn't think he did anything wrong. And the Federal Circuit doesn't think he did anything wrong. And the Ptab said, no, you can't have this patent, Josh. We're taking it back. They've now said it's invalid.
I want to ask you a little bit more about your case. Can you tell us how much it cost and how many legal proceedings have you been dealing with up to this point?
Yeah, my case, so we've had 4 cases in the regular court, major cases, thousands of filings. And we're fighting mainly telebrands, but then they would basically conspire with the retailers to avoid the court injunctions. And so we had to file suit against some of the biggest retailers in the world, the biggest retailer in the world. And then that led to these proceedings at the Ptab where there were 8 different challenges on my 6 patents. And those together led to a series of appeals at the Federal Circuit, the Court of Appeals for the Federal Circuit, which is the second highest court in the land. And we were actually there 14 different occasions because they would challenge everything. It's unbelievable how long and costly they can make this when they go nuclear with litigation. And so they would appeal preliminary injunctions and motions to transfer. They wanted to take me from my home state to their hometown, their home state in New Jersey. They would appeal these decisions, the Ptab, if they didn't go their way. It was unbelievable. It was, you hear about the patent wars like Apple versus Samsung. This is the same system that a small business has to go through, where it costs tens of millions of dollars, and it takes, you wouldn't believe it actually takes about 10 years to get through these disputes over patents, the way the system has become. And so we ended up, after 4.5 years, the legal bill to stay in this game is about $75,000 every week. I mean, that was pretty much my annual income when I quit my job to be an inventor. And now we've got to come up with this money every week. And if we can't pay the bill, then we have to walk away and lose our rights. And so after all this time, we ended up spending $20 million in legal bills, fighting over water balloon technology. So the system's completely off the rails. The Ptab is the absolute worst idea, worst implementation. I call it Kafkaesque when you think about the bureaucracy and the nonsense and just the argument over words, and just basic common sense is completely absent at these proceedings, and you're faced with having to play on this very foreign territory where what you invented doesn't have anything to do with it. What the technology has nothing to do with it. It's all a matter of, can you convince these unknown political administrative judges that your interpretation of the word is better than the other side's, who's usually represented by an attorney who they're friends with and they hang out with on a regular basis. So does that answer your question, Natasha?
Natasha, this is Ray. Can I add a little bit to Josh's?
Yes. Yep. Go for it.
So, we've spent in the Ptab, in our PGR, we spent well over $700,000. We will appeal it. It will go to a federal court where it's heard de novo from the beginning. So it's really $700,000 to get to a real court. On top of that, with our IPR, we have what's called our 231 patent, which is in front of the court. We petitioned, and last Friday they said they would hear it despite our plea for judicial economy, because it's also being heard in Iowa, Northern District of Iowa. So if we get conflicting judgments, say the Ptab rules that the patent is invalid and it's upheld in Iowa, who wins? What are the rules? We'll appeal it to the Fifth Circuit, but the lower courts have already ruled. It's a mess. There's just no rules. There's no rhyme or reason for that. So we've paid, to answer that question directly, we paid $700,000 or thereabouts just to belly up to the table in federal court where it's heard de novo.
I think there's a theme that we see here, basically large companies killing off smaller companies because they don't have the resources and the huge amounts of money, time, and financial burden that it puts on inventors. So a question for both Randy, Josh, or any other panelists. After invalidation, why can't the inventor sue the examiner and or the USPTO for all USPTO fees and attorney fees? Josh?
Let me first just encapsulate what Ray said, because there's several myths about the Ptab. The first one myth is that it's cheaper than regular court. And I think what you've heard here today is it's an additional cost on top of regular court of $500,000 to $1 million or more. And that's just a complete false statement about the Ptab, that it's cheaper. There's also a myth that it's faster. The Ptab for most inventors is a 3-year detour. And if you survive at the end, you can then go back to court. And then this other myth is that this is an expert agency that's going to resolve these situations fairly. And what we've all experienced is that there's an absolute gross incompetence and lack of knowledge about the technology and about the law. And so those are several myths about the Ptab that we would like to dispel through these testimonies in this meeting.
After invalidation, why can't the inventor sue the examiner and or the USPTO for all USPTO fees and attorney fees? And Josh, if you would also like to squeeze a little bit in about the lawsuit that you've just recently issued.
Sure. There is a pending class action suit by inventors who are seeking to recover both the value of their invention that was taken and the fees and expenses they paid to obtain it and then to defend it. And that's a Fifth Amendment, a basic fundamental Fifth Amendment case under the takings clause, that the government can take your property under eminent domain, for instance, but that they're required to provide just compensation when they do. And so far, the government has argued, and this covers multiple administrations, both Obama and Trump, the government has argued that when we invalidate your patent, that means you never had a patent. You never had it. And so since you never had a patent, we didn't take anything from you, and we don't owe you anything. And that argument so far has actually prevailed in the courts, and it hasn't been taken up by the Supreme Court yet, but we hope they'll come to a different conclusion. There's several other fundamental basic, as Randy described, the patent system is fundamentally built into our system of government in the Constitution and in the various patent acts from 1790, 1830, 1952. Patents are fundamentally treated as property, or they have been, but now they're being more treated as a privilege from the government, like a driver's license or a taxi medallion. And in fact, even Supreme Court Justice Thomas said recently that a patent's like the right to operate a toll bridge, where if you're privileged and wealthy and you pay a fee to the government, you can have this right and go exercise it. And so we're pushing back on all those things. We're making some progress, but this is a brand new voice in the arena. Inventors haven't been represented until very recently. And our current case is more narrow. We're actually filing suit against the patent office because the Ptab is unregulated. And so the laws, the various laws, including the American Invents Act and the Administrative Procedures Act, require that if you're going to have an administrative proceeding, they have to follow rules, and they have to publish those rules, and there has to be public input on those rules. And our current case is a case we joined in California, where the big tech companies actually started this lawsuit complaining about the Ptab because they were only succeeding 84% of the time. They don't think that's high enough. And so we intervened in that case, and we're asking to shut down the Ptab and pass some rules to make it fair. And so if that's successful, there will be a 60-day period where the public will be able to participate, and we're going to need to all join in and address the injustices and request fairness and due process in these proceedings. So there's going to be lots of opportunities coming up for inventors and patriots and anyone who wants to see justice and innovation to participate.
Hey, Josh, can I add something here? I think it's important for us all to understand that, we're involved in the legislation and fighting this fight from a rules perspective with Ptab, but you got to understand, and everybody out there needs to understand, and they need to share it, and they need to talk about it. But when these things float down the river and you have hypoxia and you have red tides and things like that, that's the real effect of what these things are doing. Big people that we compete with have no interest in this being efficient. They'll make millions, but save, and spend billions. So, I think it's important that everybody realizes the everyday effect that this has on people. And whether it's, every inventor out there, I've seen remote locks, I've seen, nitrogen fertilizers, I've seen all kinds of things that, affect people's lives. But it's not just the fight, the legislative fight and all this. People need to share why this is important, because nobody wants the cure for COVID or cancer or Alzheimer's to come one day too late because inventors don't have incentive to invent.
You're absolutely right, Ray. And, to win this fight, we really need to increase the number of people who are behind us. And what you're describing is the mass public should be behind this fight for the very reasons you're talking about, as well as inventors and small business across the country. Small businesses have to deal with and compete with multinationals every day. Multinational corporations are becoming more and more monopolistic and more powerful because they don't have disruptive competition, because the competition has its patents invalidated, so it can't compete. So this is all part of this effort to get enough people behind us and behind this effort to make it a real issue for our legislators. That's really what we need to do.
Can I chime in a little bit here?
Yes.
First of all, 100% agreed. Just to the cost aspect, in our case, we spent between $1.5 and $2 million just on the IPR process because there were so many of them. So that deals with the cost issue. Talking about societal issues other than the effect on inventors and inventions. In our case, after our patents were invalidated, we essentially quit marketing into the gas turbine, a market that we actually created. And since that time, which has now been whatever it is, 6 years, there's not been a single turbine inlet chilling job done in the United States as a direct result of this. So it's an irony, but even our competitor lost in this case because they can't follow us around anymore. And so since I'm speaking to inventors, here's some advice. This is what we do today. We no longer rely on patents at all. We switched industries. We're now into modular data centers. And we try to protect our intellectual property through partnerships and secrecy, basically. And if we have filed for a patent, but that's almost window dressing, because we know in the end it's really not worth anything. But some investors still think they are worth something. So there's definitely a negative impact. And as for myself, I've been an inventor all my life, but today I'm in real estate. And the reason is, at least with real estate, so far our laws still protect real property, unlike intellectual property. And then finally on this, and by the way, if any of you are unfortunate enough to get into an IPR process, I highly recommend, if you're going to hire an attorney firm, you get somebody in DC that's in bed with the Ptab, which is what our competitor did, and it turned out to be the winning strategy. Because as I did a lot of back analysis, how could this be, looking at the argument, and none of it made any logical sense. So the only conclusion I could come with is they just hired the right attorney. I couldn't come up with any other logical explanation on how they came to their decision. And most of these will get overturned by obviousness, and with obviousness and with the Google Internet, you can just deconstruct any claim. I don't care how crazy it is. And if you just take each word and you Google that word, you'll find somebody that did that, even if it has nothing to do with your industry. And then they'll just say, well, it would be obvious to combine all these different things when it's not obvious at all. And I'll stop right there. But
if I can add one thing to what Tom has said, I think one thing we've missed here is that, we talk about the invalidity rate. One of the things is the compensation of these Ptab judges is somewhat based on their invalidating patents. So there is a compensatory factor there that factors in also.
There's some very interesting points raised there, such as should an inventor even bother getting a patent? And I think that's definitely a discussion topic for another webinar. And we are running out of time, but I would like to thank all of our guests, all our panelists today for contributing their stories. Now, we're going to record this webinar. We're going to put it on US Inventor along with other questions that we were not able to answer. But I would like to finish just by letting you know that there is a sheet that I see Josh posted, which is fact versus fiction. And I highly recommend that you read that because it will give you the opportunity to see what the Ptab are giving out as communications versus the reality of the situation. Now, to finish off, once again, I'd like to thank every single panelist and for everyone for joining, but we're going to watch the trailer for Invalidated. I highly recommend watching this documentary.
When a father of 8 invents the toy of the year,
I'm here with Josh Malone, who's an inventor who came up with an awesome thing called Bunch of Balloons.
He hopes the invention brings financial security to his family.
It was one of the most popular projects on Kickstarter. It raised almost $1 million.
But his genius idea is stolen.
It was exactly our product, and they had put a different name on it.
They took it apart, and they painted it blue, and they went and shot this TV commercial.
It was so disturbing.
Thrust into battle to save his invention.
When we go into Walmart, kids are like, Dad, there's the knockoffs.
This is wrong. We have a patent. It's going to be over. This is going to be a fight. We need to call him, tell him to stop.
He uncovers the shocking truth.
Easier and cheaper for large companies to simply infringe patents.
That property rights are at risk.
The biggest winners are the lawyers. The losers are almost everybody else.
And American innovation is dying.
We're demotivating the actual creators of our future.
You can be anything except an inventor.
Learn how big tech companies, China, and our own patent office are robbing American inventors of their ideas, their labor, and their financial investments.
The tech industry and the internet economy has put intellectual property under attack.
They want to dilute the patent system.
China steals U.S. intellectual property, $600 billion a year.
Enough of stealing the ideas of these inventors.
Congress created an out-of-control administrative tribunal, the death squad for patents.
Invalidated. The shredding of the U.S. patent system.
Randy, if you would like to put a final word in there for everyone, please.
I want to thank everybody for participating. To all the panelists, thank you very much. And to everybody watching, this is such a key issue for the future of this country. And I want you to follow U.S. Inventor, myself, Josh, and let everybody you know about this issue. I've found that virtually everybody I talk to finds this of great interest once they know about it. Just normal people out there who aren't inventors, but they care about America and they care about what makes America different than the rest of the world and what's important to this country. And this is one of those things that's so important if we're going to have a country, you know? And so I would say help us out by getting the word out, making sure that everybody you know signs our resolution. And when we need your help us. We may need you to call your representatives or senators. We may need you to give input on these rule changes. Once they actually do get rule changes that we need to give input on, help us win this fight. It's very important. Thank you.